Well, good morning, folks. On this sunny April Wednesday, it's nice to see that yellow orb in the sky after a few rainy days. Although I looked at my weather app this morning and it said it was 29 degrees and it feels like 16. But the good news is baseball has started and warmer weather is coming. So welcome. This is the New Hampshire Tech Alliance HR Exchange. My name is Jim Reedy. We are coming to you from Sheehan Finney. We proudly sponsor this program, and I'm thrilled that you be with us today. We've got over 400 people registered, so really looking forward to Jen's presentation. And today we're going to be talking about managing leave and attendance under federal and state leave policies. Talk about that in just a second, but in the meantime, just a little bit of housekeeping. Couple of upcoming events on April 17th, the New Hampshire Business Review and Sheehan are offering a webinar. Jen Meckel and Andrea Chatfield, along with Liz Hodgkins, are going to be talking about mental health, wellness, and issues in the workplace. And it's an important topic for sure, and one that a lot of employers need some assistance with in identifying issues and resources available for their employees. Our program year ends for the Tech Alliance in June. We give July and August off before we start again, and it's a year in review, and that's our program that's going to be on June 18th. In the meantime, between April and June, we have our annual program in May. That's our 37th, if you can believe it, annual Labor and Employment Law Seminar, and that is on May 22nd at the Castleton in Wyndham. I'm thrilled to report that the program is sold out. It's sold out probably the earliest ever, and that we're at capacity of nearly 300 attendees. That being said, we do have a wait list, and if you have not yet registered, you can register by going to, there's the QR code, and you can also go to our website and register for that event. We do reach at least a number of people on the wait list every year. So if you haven't yet, or you know someone who hasn't registered, you certainly can. And you'll see the topics we're going to cover. And we're really looking forward to it. We've got a couple of surprises in that program too that we haven't listed yet, but really looking forward to that. And also, again, looking forward to warmer weather at the Castleton. So a couple of housekeeping items for today's program. This program is eligible for HR credits, and those will be emailed to every attendee, along with a video and a copy of the presentation. So this is a complete package for you folks this morning. And the Q&A, you can put your questions in the Q&A section, and depending upon how things are going in the program, where Jen is in the program, she will either answer it then or at the end, but certainly we'll be able to respond to your questions during the program. So without further ado, I want to turn the program over to Jen Meckel, my colleague and partner, and someone that I know like most folks in our group, can cover a wide variety of topics, but today's topic is dealing with state and federal leave laws, and what is often referred to as the awkward intersection. And a lot of employers that we represent have operations beyond New Hampshire and beyond, and with that have to look at leave laws in other states. And of course, you want to spend a lot of time recruiting and retaining talent. And some of that is managing not only attendance, but also leave policies, your internal leave policies, but also ones that are dictated by federal and state law. So Jen certainly is prepared to talk about it, and I'm going to stop talking and turn it over to you, Jen.
Well, thanks very much, Jim. I'm excited to be covering this topic this morning, and look forward to spending time with you all. Thank you for registering and participating. We have a lot of ground to cover in the next 90 minutes or so. And to kick us off in terms of the introduction, I decided somewhat late last night, so bear with me. I decided to really focus on the managing part of this title, in addition to also providing detail about some of the laws. But it occurred to me, this is a conversation I've had with employers over the last 30 plus years, and it occurred to me that we often dive into the weeds of the details of every law The details matter, don't get me wrong, I love a detail. But we sometimes skip over in these presentations how to really skillfully and compassionately manage leaves of absence. And it occurs to me that frequently an employee is taking leave when something has gone terribly wrong in their lives. Sometimes, of course, it's for a happy reason. They're welcoming a new child into their life or something else wonderful is going on. But we know statistically that the most frequent usage of leaves of absence is when the employee themselves is injured or ill. And so, that means something's gone wrong for them. And how we manage leaves, how we communicate about them, how gracefully or not we manage the process, and how we welcome employees back matters a great deal. So I wanted to spend some time focusing on that first, and then we'll talk about some of the laws as well. I hope that you find this, again, it's not the way I normally do the presentation, but I just was having this thought last night that it might be helpful for you all. So when I think about how to skillfully and compassionately manage leaves of absence, the first thing that comes to mind, obviously, because I'm a lawyer, laws are near and dear to my heart, are making sure that you know and understand the laws that apply to your workplace and to your employees if they're not in your workplace. As Jim mentioned, of course, many of you have remote employees. To manage a process well, you have to have a thorough understanding of each of the parts that create the foundation of that process. And I mentioned that some of you might be thinking, gosh, duh, Jen. Yet, in so many conversations with very bright, very experienced human resource professionals and finance professionals and others who manage these things, they don't really have a clear understanding of these laws. And I don't say that as a knock. I'm someone that devotes my time to this. So of course I've got an understanding, and even then I have to research things. But my point with this slide is, with some of this, with designing your leave management process, you got to kind of start from the ground up. And that ground level, the foundational level, is understanding the laws that apply to your workplace and to your people. Not just a passing familiarity, but having a good grasp of these things. What are some of your resources for gaining that understanding? Seminars like this, articles, law firm blogs, we do client alerts, as do other firms, governmental websites. Some governmental websites are more informative than others, but some are quite good. Don't overlook them. And then also your organization's employment law counsel. Of course, you should always think of your friendly lawyer. And then when you're thinking about the laws that apply to your workplace, make sure as well that you've got a decent understanding of how to figure out which state laws apply to your remote employees. Frequently, someone who's working remotely will have their workplace, they'll have a primary workplace. Perhaps they're primarily working from home or primarily working from a major client or customer location or that type of thing. And if someone's got a primary work location, it's likely that the laws of the state, that location, will apply to them, not the state in which you're headquartered. If someone's work is not localized, there's a detailed analysis that you can follow to take a look at whether if their work is not localized, where are they receiving their instructions from? Do they have a base of operations, et cetera, to come to a conclusion about which state laws apply to them? I mention that because it's useful to know ahead of time and not in a time of crisis, although we're also good in a crisis. And if you need to call at the last minute and figure something out, we can do that too. All right, so once you've got, and of course, in this seminar, I'm going to give you some of the basics on the laws as well. Once you've got an understanding of the laws, what's next? You want to know and understand the benefits that your organization offers. Again, you might be thinking, yes, I know, yet. It's not that uncommon for me to be having conversation with someone who says, yeah, sure, we offer short-term disability benefits. And yeah, there might be a 7-day waiting period, but I don't know when it applies or how it works. I don't know how long it takes for someone to get benefits. And if I'm topping off the benefits, meaning someone's getting their 60 or 66% or whatnot, but I'm paying a little extra so they get 100%, I don't know how long it takes them to get the check or how I calculate that or how I figure it out. My point on this being, if you figure that out sooner rather than later, if you don't know the answers to some of these questions, don't beat yourself up. Some of this stuff gets tricky, but reach out and call your broker or call your insurance carrier to say, hey, could you walk me through a hypothetical claim? Could you help me to understand how this works? That will help you help employees when they need it. It might also help you to tighten up your process and design things. So always ask for help. People are there, your brokers and others are there to help you. Same thing is true. My next note here is about understanding health insurance continuation for people who are on leave. We know that there are some laws that require people to, require you to have people continue to participate in their health insurance. The federal FMLA is an example. We know that so long as the employee is paying their share of the premiums, they get to continue during the 12 weeks of FMLA. But there are other forms of leave where it's not so clear. My point on this being that it is useful when you're designing, say, a personal leave policy, which we'll talk about later this morning, or working with someone taking a leave of absence as a reasonable accommodation. It's useful to know ahead of time how long your specific health insurance policy allows an employee on leave to stay on that policy without having to invoke COBRA. It's useful to ask the question ahead of time, again, to help you design policies and procedures that are accurate. We're setting the foundation here for that skillful management, and it starts with understanding, and not just a generic understanding, but understanding your workplace, your benefits. Another thing I like to talk about, and this part always makes me smile because I had a mentor early in my career who walked me through what I've got on this slide. And it was like a light bulb moment for me. And those of you who know me have probably heard me do this before because it's a light bulb moment. It is about having clarity between the difference between an employee's status with respect to your organization and their income source, if any. Why does this matter? Because if you don't have that clarity, sometimes it gets blurry. For example, it's not uncommon for an employer to call us up and say, hey, I have an employee who's out on workers' comp. But workers' comp is not a leave status. Workers' compensation benefits give someone money, indemnity benefits, the ability to seek medical care. Workers' compensation benefits are important and have a role. But there is nothing in our New Hampshire workers' compensation statute or the Massachusetts one that says there's a leave of absence. So it's not a status with respect to your work. So what are statuses? Well, firstly, the normal status is that someone can be actively coming to work. Whether they're fully engaged or not, that could be a different story, but they're actively coming to work and they're earning their wages, salary, or other forms of compensation, their commissions and whatnot. Another status is someone who is inactive, meaning they are away from work. That could be a short-term absence, a PTO day, a sick day. In Massachusetts, maybe an earned sick time day, bereavement leave, if you offer that at your organization, jury duty pay, any of those things might be filling in on a short-term absence. Or the person their inactive status could be a long-term absence. And examples of that, of course, would be like the federal FMLA, or it could be the Massachusetts Paid Family Leave Program, or here in New Hampshire, our voluntary paid family leave program, military leave, any number of leave statuses. But notice in the other column there, under income source examples, I have short-term disability. Why? Because again, oftentimes people will say, well, the person's out on short-term disability. Short-term disability doesn't give you permission to be away from work. Short-term disability doesn't protect your health insurance benefits. Short-term disability gives the employee money while they're away from work. Again, it's a very important benefit, but it's incomplete. The point on this notion here, when I'm thinking about a long-term absence where someone's income source might be short-term disability benefits, or maybe workers' compensation benefits, maybe pay through a PFML program, or maybe the employer has a paid parental leave that they offer themselves. The point being that these two things operate together to provide a complete package. And if you're not communicating with the employee holistically about both their leave status with respect to your organization, what's giving them permission to be away from work, what are the rules of the road of that particular form of leave, and what their income source is, If you're not putting those two things together, the employee's not getting the full package. They're not getting the full benefit of the benefits that you offer. Other statuses less relevant to our conversation today, or someone could be a former employee because they resigned or you fired them or whatnot. It's a permanent separation. They're not coming back, or you don't anticipate they're coming back. Their pay, if any, could be final wages, possibly severance pay if you offer it. And then the final one is one that you may or may not have thought about before, which is someone who's been conditionally discharged. A weird phrase. I just stumbled over it. But what does it mean when someone's been conditionally discharged? It means you have said goodbye to them, but it might not be a permanent goodbye. You know, for example, you might have someone on a seasonal layoff. You expect them to come back. Or importantly, workers' compensation rights in New Hampshire anyway, and some other states as well, give someone a right of reinstatement, the right to come back to work within 18 months of their original date of injury. And that can be true even if you say goodbye to them in the meantime because they've exhausted all their other forms of leave. And so it's about having clarity about where people stand with your organization and being able to communicate with them clearly about it. My next thought, to again help you skillfully manage the leave of absence process, is to know your own rights as an employer. They vary a bit. The slide's generic. The rights vary a bit depending on the law that we're dealing with at the moment. But in general, you have a right to know whether the employee is working or not. And if not, why not? And you might say, you know, goodness, of course I can tell if someone's working or not, but it's not always so easy. If you have someone who's working at a remote location, whether it be their home or a customer location or whatnot, you may or may not have a really good read on that. I think it's important when you're designing your remote work policies, for example, to talk about the fact that remote work changes the location, but not the scheduling and attendance expectations. That you still expect someone to be readily available during working hours. And if they're not going to be, to, you know, talk with their supervisors about their need for time off. For example, if someone has a medical appointment or they need to pick a child up from school or care for someone else, you know, or they have someone coming to, you know, service their boiler. This is something I did last week. If they're going to be away from their desk, they ought to communicate with someone about it. So it's having clarity about whether the person is working or not, and then why not. And when I say why not, I mean, you have to at least have a general sense. And I say this because often people are reluctant to say to an absent employee, you know, why are you out? What got in your way of coming to work today? What's going on? That type of thing. And I am not suggesting that at this phase, just someone's been out, you know, for a day or two or whatever, that you're drilling down on, do you have a medical problem? What is it? What's your diagnosis? Have you been to the doctor? No. I'm talking about a general sense of, is the person out for a medical reason? Are they sick? Is a family member sick? Are they having car troubles? Something else going on? We want to have a general sense of what's going on. This becomes important too, not only to help you to figure out whether you should be thinking about a leave of absence, and if so, what type might apply, but it becomes important later if someone is taking leave on an intermittent basis. You want to establish the importance of having clarity when someone is sometimes in or out about telling you why they are out. Because if someone is taking intermittent leave, for example, because they experience, say, migraine headaches, yet on a given day they're out because their basement flooded, you want to know, oh, this was a basement flood day. I should not count this against their FMLA. So getting into the habit early with employees about communicating some general sense of why they're out is important, and not being afraid to ask. You also have a right to receive information sufficient to allow you to determine whether any forms of leave of absence or benefits might apply. You know, sometimes people will say, well, I don't have to tell you, that's HIPAA. Well, you got to give me something. You know, you got to at least tell me, are you out because of your own health issue? Even if you don't want to tell me yet what it is, depending where we go, you might have to give me more information later, but, you know, give me a clue now. You have a right to receive communication and reasonable updates from an employee on leave. You might have had the experience, I know so many employers have, where someone is placed out on a leave of absence and then you don't hear from them again for, say, 12 weeks. And then at the end, you're like, oh gosh, they're supposed to come back to work Monday. No one's heard a thing. who knows if they're coming back or not. We're going to talk in a minute about having better communication with people, but you've got a right to updates. People should communicate with you. And you have a right to return to work information. For example, a fitness for duty certificate if an employee is out on leave for their own illness or injury, or, you know, if it was a military leave, for example, you have a right to receive paperwork showing when the person's deployment or military service ended, so that you can ascertain, yep, they got back to me promptly, they're within that window for reinstatement, and this is what I need to do to properly reinstate that service person to work. So those are some of your rights. Next
Jen?
thought. Yeah.
Jen, sorry to interrupt you. I wanted to catch you before you moved on. We did have one question that says, can a right of reinstatement apply to FMLA?
Can you repeat that, Liz? I couldn't hear part of it.
Yeah, can a right of reinstatement apply to FMLA?
Yes, I guess I'll answer that a couple of ways. Number one, we know that if someone is taking FMLA leave, they have a right of reinstatement at the end of that FMLA leave, assuming that they're coming back within 12 weeks time, which is our maximum federal FMLA. They will have a right of reinstatement to their same or an equivalent position unless they are a key employee. And if they are a key employee, there are certain notice requirements that you have to give. If you're going to potentially deny reinstatement, and for a key employee, you have to be able to show that you cannot reinstate them because reinstating them would cause substantial and grievous economic injury. And if what the person who is asking the question meant was, how does it work if you have someone who's out on workers' compensation, out receiving workers' compensation benefits while simultaneously using FMLA leave, those two things would work hand in hand. Let's suppose that someone is out on FMLA receiving workers' comp, 12 weeks go by, but the person's not sufficiently recovered to be able to return to work. You might provide them with a different form of leave after their 12 weeks of FMLA expire. For example, like we'll talk about, they might qualify for leave as a reasonable accommodation under the Americans with Disabilities Act, which can also overlap with workers' comp. But at some point, if they've exhausted all leave, you might say goodbye to that person who's had a work-related injury, yet they might still have that right of reinstatement to come back to work if they regain a work capacity within 18 months of that date of injury. That's true, by the way, even if you've hired a replacement employee. You might be obligated to boot the replacement and bring that person back. So I hope that answered that question. My next thought on skillful management of leaves of absence is about communicating early and often. Literally, if I wouldn't be mortified to do so, I would jump up and down and scream about communicating in a good way, because so often when we see things go wrong, when things go south, when employees feel mistreated, or perhaps even feel their rights have been violated, so very often it's because the communication has not been clear. So I cannot say enough, even if I were to jump up and down and yell and use exclamation points and everything, I cannot overemphasize the importance of good communication. And I mean communication in every aspect, starting with a clear attendance policy and call out procedures. Say what you mean and mean what you say. For example, often an attendance policy that I will see says that a person has to phone their supervisor, have an actual conversation when they're out. This can be helpful because in actual conversation, you can perhaps better learn while the person is out. Yet in practice, many people will just send a text. And if it's okay in your workplace for someone to text, if that works for you, then your policy should reflect that and should reflect what the person should say in the text message. If it's not okay in your workplace and you actually want a conversation to occur, you can say that, but then enforce it. Say what you mean what you say, and have that clarity. You want to ensure that supervisors timely address attendance and tardiness issues and effectively document discussions in any disciplinary action. It is something that we see with some frequency that someone will be having trouble coming to work. Let's suppose it's someone that is struggling with a health condition like sleep apnea, for example, and it makes it difficult for them to wake in the morning and to timely get to work. You might see some tardiness. It might go unaddressed. Maybe the supervisor is feeling frustrated, but they didn't know what to say or how to say it. Or maybe they've had some verbal conversations about it, but no documentation. And then the employee presents medical documentation saying, I need to say take reduced schedule FMLA leave to allow me to sleep in the morning or take care of myself in the morning, whatever it is I need to do. And that's fine. Of course, we can administer FMLA, but my point on timely addressing things is it happens that sometimes when someone comes back from leave, or if they're taking leave on an intermittent or reduced schedule basis, that the supervisors will then be paying extra attention to attendance, tardiness, punctuality, and then they will want to start documenting things, maybe disciplining, perhaps even saying goodbye to someone. But if we have not set the groundwork for that before the implementation of leave, doing it during or after the leave can look retaliatory if not done carefully. I'm not suggesting that your hands are tied and that you can never address these issues after the fact. I am, however, suggesting that part of clarity with an employee, part of treating an employee decently, is to let them know what your expectations are, and then to talk with them about those expectations and to document those conversations. For absences due to ongoing medical reasons, get human resources involved early so that medical information is revealed only to human resources and kept confidential, unless someone else has a legitimate need to know. There are some employees, of course, we've all employed them, that are oversharers, and they will tell you anything and everything about that health condition. They'll tell everybody. And if that makes them feel good and supported, so be it. That's their prerogative to talk about their medical condition. But many people are much more private, and they don't want unnecessary people to know about their medical conditions. And we know that under the Americans with Disabilities Act, which we'll talk more about in a minute, we have to keep all medical information confidential, and we can only share it with people who have a legitimate need to know. So it is useful to have one point of contact, human resources, if your organization is large enough to have an HR department. If you're in a smaller organization and don't have human resources, but you've got someone that wears the HR hat, and maybe you're a head of finance, maybe an office manager or whatnot, have that person be the funnel for that medical information. And then what you can do is, if a person's calling out and if the supervisor is getting the call in the first instance, you can train that supervisor just to say, hey, what's going on? Are you out for a medical thing? Okay, let me connect you with HR. And then HR jumps in from there. An example that I have here is a supervisor might need to know that an employee is out on an approved medical leave, but they don't necessarily need to know what the person's medical condition is. Let's protect that medical privacy when we can. What are some other tips on communicating early and often? Have clear policies outlining each type of leave of absence and benefits offered by your organization. Spend time on this. When I'm working on employee handbooks, for example, I spend a lot of time on the leave of absence section and really work with the employers about some of the choices that they have under that, making sure employers understand the mandatory parts where there is no choice. But the whole idea here is to have something that's reasonably clear, even if it gets a little long, but that people can look at and refer to. Again, particularly if you're helping them at a time when they're unwell or someone they love is unwell. I think it is so important to make sure that communications are easy to understand. We might have all seen circumstances where something's gone terribly wrong for someone. They get a very serious diagnosis and they're frightened. And then lo and behold, in the mail shows up a stack of FMLA forms and a stack of short-term disability forms with no cover letter, nothing tying it together, nothing explaining why they need to fill out both forms or what the deadlines are, what assistance human resources might provide. So my encouragement here is to consider creating template cover letters. I mean, you can create unique letters each time if you want, but if you've got enough employees taking leave, having a template that you can customize might just be efficient for you as part of your leave of absence management process. But try to think about different scenarios where people take leave. and set up some cover letters that are kind and clear and walk a person through the interplay of these things so that it's not confusing, or is as least confusing as possible, because I do understand that this is a tricky area. But for example, for someone who's going to be taking parental leave, if your workplace is covered by FMLA, which we'll talk about in a minute, if they're eligible, they might be experiencing an interplay of FMLA, PFML if it applies to them, or short-term disability, state parental leave laws. They might be using some PTO. There might be all kinds of things happening for that person. And if we don't help them understand and write it all down so that we're literally on the same page, that the employee and the person administering the leave fully understand what's going on, then we've not done a good job administering that leave. And it is in that lack of clarity where problems arise. Questions arise. People feel forgotten or misled, for example, even if that was never the intent. Another scenario that you could think about for creating a template letter would be the employee who's out for their own serious health condition. Maybe they're also FMLA eligible, or maybe they're on a different form of leave. Maybe you've got a more general medical leave or a personal leave, which we'll talk about. Maybe they're receiving short-term disability, workers' compensation, how all those things come together for them. Again, tying together their status and their income source, putting it together so that they understand the different expectations of them. And the point here is to be clear with employees about their rights and responsibilities. Another part of communication is that if you've asked the employee for documentation, such as a medical certification, please don't wait and play a game of gotcha. Don't just wait for the time to go by. For example, if it's federal FMLA, you've got to give an employee 15 days to get that medical certificate back to you. Don't wait till day 15 and say, aha, you didn't get this to me, and therefore your leave is denied. That's, first of all, if you go to court on that, a court's going to probably want to see that you made some more efforts. It's not going to look great just to yank the rug out from under someone. And secondly, the whole point of a leave of absence is to welcome the employee back into your workplace. So you want for them to feel well treated and cared for while they're out on leave. When I'm assisting employers with employees on leave, I often think about how would I want for this employer to treat, my mother, my sister, or my daughter, or, father, brother, son, if they worked at that place. How would I want someone I care about treated? And that's what I want to help the employer do. That's what I think your goal should be. And again, the goal here is retention, as Jim mentioned, as well as legal compliance, and making sure that people don't feel that their rights are being interfered with, denied, or that they're being retaliated against for seeking or taking leave. So don't play gotcha. Instead, consider reminding the employee of the deadline and maybe giving them another copy of the form. For example, if the person has 15 days and you're coming up on, say, day 12-ish, you haven't heard anything, you could ping them and say, hey, I hope you're doing all right. Thinking of you, as a reminder, this is your deadline. In case you need another copy of the form, here it is. If I can help you in any way, let me know. Another example of this would be calendar for yourself, dates for checking in with the employee. The cadence of that's going to depend on the length of the leave and the reason for the leave. You don't want to pester someone. You don't want to be checking in all the time. But I have worked on so many matters over the years, some of them that have dissolved into, claims at the Human Rights Commission, EEOC, and other agencies or courts, where the employee says, no one even reached out to me. Nobody checked on me. Sometimes the employer is thinking in response, you were on leave. I didn't want to bother you. I didn't know I could reach out. My encouragement is be human, be compassionate. Don't pester, don't reach out all the time, but a note that just says, hey, we're thinking of you. If there's anything I can do, let me know. Or we hope you're doing all right. Or for example, if you know that someone has had surgery and they've just been discharged home, could you send an actual note, a card, or, a small gift, flowers? Is there something you can do to let that person know that you're thinking of them in some way? And you don't have to, it doesn't have to be expensive. And then also plan to check in at least 1 week before the scheduled end of the leave to be sure that the person is planning to return as scheduled, to make sure that you and they have the same return to work date in mind, to remind them of anything they need to do. For example, are they supposed to provide you with a fitness for duty certificate from their healthcare provider? Do you use a particular form for that? Do they need a copy of their job description for the healthcare provider to review? You might have given them one back when their leave started, could have been misplaced in the many weeks. What can we do to make that process smooth? Sometimes employees need reasonable accommodations, light duty, job modifications, other reasonable accommodations when they're returning to work. If you don't talk about it ahead of time, you won't be able to prepare and you won't have ample time to engage in that interactive process. Speaking of ample time, I suggest at least 1 week, because you might decide to check in 2 weeks at a time or 10 days or something to give yourself a little bit of extra time. You also want to work with the supervisor to plan for that employee's return. Literally make sure the supervisor knows when they're coming back. Make sure that you've had a conversation with the supervisor about welcoming back. And that welcoming back does not mean just having someone sit at their desk and wade through weeks and weeks and weeks worth of emails. There could be another plan. Could somebody sit and have coffee with them, take them to lunch? Could someone update them on important developments while they've been gone? Could someone lend a hand? How do we really welcome that person back to work? And then if someone's returning from parental leave and if they're nursing, you might also want to plan for lactation breaks. If you don't have a lactation room, a specific room, you might want to plan for what is that space going to look like? How are the breaks going to take place? That's good for you and your organization to know to plan, but it will also help put the employee's mind at ease, that they're being thought of, that things are being worked through, and that they don't feel that they have to go into, fight mode to fight for these things. They know instead that things are being proactively thought of and communicated about.
Jen, I'm going to jump in again if you don't mind. You have 3 questions this time.
Goodness.
Yeah. Hot topic. So the first one, let's see how we can do these. The first one, when an employee returns from LOA with a doctor's note that states long-term accommodations that is a hardship for the company, can the employee be let go?
Okay, let's tackle that one. We're going to talk in a few minutes about the Americans with Disabilities Act. But what you would want to do in that circumstance is make sure that you engage in the interactive process with the employee, because having the doctor's note should trigger you to start the process, but the interactive process of exploring reasonable accommodation should be a back and forth dialogue, a documented back and forth dialogue. You can talk, but then document what you're doing. And you want to make sure that you really understand what the healthcare provider is saying. You want to potentially explore if what the healthcare provider is saying is not something that you believe is going to be doable within your organization. You might want to explore alternatives. Maybe the healthcare provider hadn't thought of them. Maybe there's something that is doable. So you want to make sure that before you ever get to saying, we can't do this, that you've done a good faith interactive exploration with the employee and with input from the healthcare provider and everything to really explore what's possible. And then if there's a circumstance where you cannot accommodate the employee in their existing job, that it really would cause an undue hardship, which is hard to prove, by the way. You might also be able to conclude it's not a reasonable accommodation. Again, we'll get to that. But if you get to that place where you're saying, I don't think it can work in this position, you should also look to see whether you have any other vacant positions within your organization for which the person might be qualified, in which you might be able to accommodate them. And then if that is not possible, then take a look at whether the person's exhausted all of their forms of leave. Maybe they took some of their FMLA weeks, but not all. Maybe you give them some additional weeks to see if that can improve their situation. But once everything is exhausted, then yes, you can get to the point where you can part company with someone. The point that I want for the questioner to take home is it should be a slow, thoughtful process in getting there, not a knee-jerk reaction of we can't do this.
Okay, so we actually have 4 more. They're coming in. Bear with me. The next one is, how would you handle an employee who notified us retroactively of FMLA used for the care of their 19-year-old son who could have provided support for themselves?
In that case, first of all, for FMLA leave, to care for a child, either the child has to be a minor child under the age of 18, or if they are over the age of 18, they have to be incapable of self-care because of a disability. So if that 19-year-old child was not incapable of self-care, like if we don't have medical documentation showing that they were incapable of self-care, then the person would not be FMLA eligible. If, on the other hand, there is medical documentation suggesting that the 19-year-old was incapable of self-care because of a disability, then the FMLA regulations do allow for retroactive designation of FMLA in certain circumstances. One of those circumstances is with the agreement of the employee. But what I would say is that you want to get clarity from this, the young adult's healthcare provider as to whether they were capable of self-care or not capable of self-care.
Okay, we got quite a few more. What is the best way to manage employees with lifelong conditions that have exhausted FMLA?
So, depending on the nature of the condition, I guess the first thing I'll say is sometimes FMLA is not ever exhausted if someone is taking it intermittently. For example, someone could have a lifelong condition of migraine headaches and never run out of FMLA leave because you get 12 weeks a year and it perennially renews. So there's that. But the question presupposes that FMLA has been exhausted. What you would then do is consider, is there any other form of leave for which the person might be eligible? Might they be eligible for leave as a reasonable accommodation under the ADA? We're going to talk about that in a few minutes. It depends on whether the person needs an indefinite leave for an unknown amount of time or a specific leave. Again, we're going to talk about that a little bit more. If the person needs indefinite leave, then you might end up to a place where you ultimately conclude that you're going to administratively separate that person from employment, meaning saying goodbye to them because they've exhausted all forms of leave. But again, getting there should be a slow process. You should make sure that you've extended all forms of leave, that you've engaged in that interactive process, that you've documented everything before you ultimately say goodbye to the person. The reason I use the phrase administrative separation is because my intent is to imply that the person's done nothing wrong. It's just that they've exhausted all leave available to them.
Okay, next one. You have not mentioned an ADA accommodation of additional job protected leave, which in most cases should be reviewed at the exhaustion of FMLA. Can you speak on that?
Well, I just mentioned it in response to these questions, and I
Yeah.
have a whole section on the ADA coming up. So
Okay.
please bear with me. What we're doing right now is setting the foundations about how to manage leave in general.
All right, so we've got that one covered. Can you start the interactive process before you receive a doctor's note requesting accommodations if you're aware of the employee's condition?
Yes. The short answer to that is yes. If the employee has disclosed to you a condition, one of the best things to do in response is to say, how can I help? And that will often get, the employee might say in response, well, it would help if I had a modified schedule, or if it would help if I would have this or that. And you can absolutely start that interactive process. And along the way within the process, you might well say to the employee, could you please provide some medical documentation? But you do not have to wait for the presentation of a doctor's note to get started. So these are great questions. I'm going to truck along a little bit more now because I can tell that some people are anxious for some of the material that comes later. And it's an aggressive topic in 90 minutes. So I'm going to keep cruising along. Okay. If the employee changes from, well, let's see, if the employee cannot return to work as scheduled, communicate whether there's additional leave time that can be granted. That gets to, exploring whether leave should be offered as a reasonable accommodation, whether you've got a personal leave policy, et cetera. If someone changes from one form of leave to another, if they have exhausted FMLA leave and you're exploring other types, you're going to place them on an ADA reasonable accommodation leave, for example, you should communicate with them that your FMLA is expired and we've engaged in the interactive process. We're aware that you need more leave. We are now transitioning you to this type of leave. So you want clarity around that. when the person comes back to work, if they're able to come back to work, you want to affirmatively welcome them back to work. Sometimes when people come back, they're feeling nervous, anxious, whatever. Be there, be present, welcome them back, say hello, send a welcoming note, whatever you can do to make their return pleasant, not just on day one, but keep following up after that. Again, not in a pestering way, but in the way that is just supportive. How's it going? Maybe a week or so in, how'd it go coming back to work? How you feeling? You know, what can I do to help? Train your supervisors. Supervisors don't have to be experts in the law, but they should have a working knowledge of when an employee might have a legally protected right to take leave and to return without experiencing any retaliation. Supervisors are your eyes and ears on this, and they need to have a little bit of a sense of when something might be going on, when to contact you. They should understand the importance of reaching out to human resources. They should know what they can ask when an employee calls out of work, when to involve human resources in addressing issues of absenteeism, tardiness, etc. And they should understand the importance of timely, effective documentation and how to do it. Sometimes supervisors or leaders, even experienced ones, find it intimidating to look at a blank screen and come up with documentation. So it is useful to provide training to people on how to do it. Doesn't have to be intimidating, but you know, there's always a fear of the unknown. So make it something that's known so they know what to do. When you're training your supervisors and leaders, also show them, teach them what it looks like to support an employee from returning from leave. For example, it looks like helping the employee, first of all, plan before they ever go out. If the leave is anticipated, how can the supervisor help that person to transfer work, transfer knowledge, whatever, so that they can really be away on leave, they can unplug, and in a way where they won't feel that they're unduly burdening their colleagues and that type of thing. You don't want to impose a sense of guilt. The supervisor can reach out to the employee to let them know they're thinking of them. That can be something that they might do, you know, thoughtfully together with human resources, or just making sure that the left hand knows what the right hand is doing so that people aren't pestering the employee all the time, but just some kind of communication, you know, thinking of you, hope you're doing well, you know, not something that begs a response, not something that imposes guilt, like, hey, we're thinking of you while we're all sweating it out here covering for you. You don't want to say that. Help the supervisor to make a plan. We talked about this, welcoming the employee back to work, and make sure that all your supervisors and leaders understand that an employee cannot be retaliated against for taking our legally protected forms of leave, and that they understand what various forms of retaliation look like. It can be subtle, not so subtle, etc. Okay. So now I want to focus our remaining time on buzzing through some of the various types of leave. Understand too, when you're listening to this, that so many of these topics could be the subject of, you know, a half-day seminar in and of themselves. So my aim here is to provide an overview and provide some resources, ask questions if you have them. But I just want to be clear about what we can achieve in the time frame that we have. The first type of leave that I think about is the federal FMLA. In some senses, I think of it because it's in many ways the clearest. If you take a look at those regulations, their questions and answers, it's fairly black and white. In contrast that, for example, with leaves of absence under the ADA, which are much more gray, they're trickier for people to understand. The federal FMLA is a law that applies to employers with 50 or more employees. It also applies to public employers regardless of how many employees they have. When people are eligible, they can take leave for certain reasons. Who's an eligible employee? An eligible employee is one that's worked at the workplace for at least 12 months. They don't have to be consecutive months. They've worked at least 1,250 hours. And the 1,250 hours of work have occurred within the 12 consecutive months preceding the leave. And that's 1,250 hours of actual hours worked, not vacation time, PTO, etc. So if an employee is eligible, then they can take up to 12 weeks of leave in a 12-month period. You should define in your policy what 12-month period you use, whether it be a rolling year, calendar year, fiscal year, whatever. Your policy should say what you use. That's important. And the reasons for FMLA leave are the birth of a child and to care for a newborn child. Sometimes people still ask me, can dads take FMLA leave? Yes, FMLA leave is for anyone that's experiencing the birth of their child, placement with the employee of a child for adoption or foster care, to care for the employee's spouse, parent, or minor son or daughter with a serious health condition, or adult son or daughter with a serious health condition if the individual is incapable of self-care. Notice I truncated that, it's incapable of self-care because of a disability. And or if the employee has a serious health condition themselves that renders them unable to perform the functions of their job. And an eligible employee can also take FMLA leave if there's a qualifying exigency arising out of the fact that certain family members are either on active military duty or being called to active military duty. And lastly, an eligible employee can take FMLA leave to care for certain family members listed here for up to 26 weeks, by the way. Normally FMLA is 12 weeks, up to 26 weeks of leave for certain family members if they've become injured or ill in the line of active duty for the US military forces. So those are our FMLA reasons. FMLA presupposes, in many cases, that there's a serious health condition, either that of the employee or certain family members. What I want you to take away from this is that a serious health condition might not be so serious. A serious health condition can be an overnight stay in a hospital. So there's that, but it could also be a condition for which the person receives continuing treatment if they're incapable of working for more than 3 days, and they receive treatment either 2 times by a healthcare provider or treatment 1 time with a follow-up regimen of care. Note, for example, that if someone has, if someone has COVID and they go to the doctor and they get the Paxlovid prescription and they're unable to work for more than 3 consecutive days, you should be thinking FMLA. Same thing if someone has a nasty case of strep throat, they go to the doctor, they get some antibiotics, and they're out of work for more than 3 days. That might not be so serious. We don't think of strep throat as being a dire condition, but it could qualify for FMLA. So you want to kind of think broadly when you're thinking about FMLA eligibility. Pregnancy, FMLA is for any period of incapacity due to pregnancy or prenatal care. FMLA also covers chronic conditions, like one of the people that asked a question asked about a chronic condition. And a chronic condition is one that requires periodic visits with a healthcare provider. And they might cause episodic periods of absence instead of continuous periods. For example, a very common usage of FMLA that I see is people who experience migraine headaches, or someone that has a seizure disorder and they periodically have seizures, need a little bit of time off to recover, and then they're fine for a while. Or someone with diabetes is another example. So you think about those chronic conditions. With a chronic condition, it might not be that they're incapable of working for more than 3 days. It might just be that it's a chronic condition that requires periodic intermittent leave. So when we're thinking about one type of serious health condition, the person has to be unable to work for more than 3 consecutive days. When we're thinking about a different type of serious health condition, this chronic condition, that 3-day thing doesn't apply. So just making sure you understand some of the distinctions there. Permanent or long-term conditions for which treatment might not be effective. You know, if someone has Alzheimer's, for example, or ALS or something like that, there might not be any particular treatment that's going to help them to get better, yet they would still qualify for up to 12 weeks of FMLA. Or someone who needs multiple treatments for example, for restorative surgery after an accident. So the point being here that when you're thinking about the FMLA, you want to be thinking broadly about all the different types of things that can trigger FMLA. You want to make sure that supervisors are trained on the FMLA, again, not to make them expert, but to help them help you in administering it, because they need to tell you promptly when someone is out, because there are some pretty short deadlines here. When you have reason to believe that someone might be out for a reason that qualifies for federal FMLA, you've got, about 5 business days, I think, to get with them and start the process. So you want to get involved quickly. If you've missed that boat, don't worry, you can always, do it whenever you learn. But the point being that someone gets 12 weeks of leave in a 12-month rolling period, and it's often in an employer's interest to start that clock ticking soon so that the 12 weeks are 12 weeks and don't slide into 15, 16 or more weeks because you didn't start the clock soon enough. Do not wait for the employee to formally request FMLA leave. A lot of employers will sometimes say to me, well, the person didn't ask for FMLA. Well, that's not what we're waiting for. The FMLA regulations expect that if an employee gives us enough information for us to be able to discern that they need to be out for something that might qualify for FMLA, we know that they're out caring for a sick minor child or their ill spouse or their own health condition. Whether they ever utter the letters FMLA or say family medical leave is of no relevance. We should be implementing that FMLA policy, even though they never asked for it, for that benefit. Use the US Department of Labor FMLA forms. I've given you a link here to the forms. They're not mandatory, but my feeling on them is the forms are pretty good. And why reinvent the wheel? Why not just go with the US Department of Labor has provided us? Employees do need to prove the need for leave through medical or other certification, and you can hold them to that. Again, don't play a gotcha game of, hey, I gave you 15 days to get me a med cert, you didn't get it back to me. Haha. You know, you want to play some follow-up with a person, reminding them. If they don't get it back to you right away, you might give them some additional time. A lot of this is, firstly, treating employees the way that you would want to be treated. And secondly, in the event you find yourself in an FMLA lawsuit, which I hope you don't, you want to be able to show that you acted reasonably, compassionately, and that type of thing, and that you weren't playing a game with the employee or you weren't trying to push the employee out or retaliate. So your actions matter and you want to document them. FMLA leave for medical purposes can be taken all at once, or as I've suggested in responding to some questions, it can be taken on an intermittent basis or a reduced schedule basis. An intermittent basis is taking, a day out now and again is needed, or a few days out now and again is needed. A reduced schedule is more of a predictable thing. For example, someone can come to work in the mornings, but they need the afternoons off, or vice versa. Or they can predictably work certain days of the week, but need other days off for treatment or recovery or what have you. So that reduced schedule is more of a predictable type thing, whereas intermittent might be episodic. It might be incapable of being predicted, because who knows when someone's going to experience a migraine or something else that happens out of the blue. You can require that employees provide a fitness for duty to prove their ability to come back to work. And employees need to be reinstated from FMLA leave to the same or an equivalent position. With only very limited exceptions. I mentioned the key employee exception earlier, and employees may not be retaliated against for taking FMLA leave. On this next slide, I have a link to the US Department of Labor employer guide about federal FMLA. If you're not really up to speed on the FMLA, or if you don't deal with it frequently, I encourage you to take a look at this guide. It's free and it's pretty good. And it will walk you through the forms, how to use them, how to determine eligibility. They answer many questions. So this guide is a useful resource. I'm going to toggle next to the Americans with Disabilities Act. As someone mentioned when posing a question, when someone is taking a form of leave, for example, federal FMLA leave, and then it expires, they use up all 12 weeks, you ought not to just be like, oh, off you go then, I'm going to fire you because your 12 weeks are over. You should instead consider, might they be eligible for any other form of leave, like leave under the Americans with Disabilities Act. Another time that we think of the Americans with Disabilities Act is if your workplace is not covered by the FMLA because you have fewer than 50 people, or if maybe you're covered by the FMLA, but your employee is not eligible, either because they've not worked for you for 12 months or the 1,250 hours, or perhaps because they exhausted FMLA on something else. Maybe they used their FMLA to have a baby, and now they got into a car accident and need leave for that, but it's all gone, so there are many different circumstances where leave as a reasonable accommodation under the Americans with Disabilities Act could be relevant. The Americans with Disabilities Act applies to employers with 15 or more employees. So much smaller employers than the FMLA, which kicks in at 50 employees. This kicks in at 15. I also want to flag for you that many states, including New Hampshire and Massachusetts, have laws that are quite similar to the Americans with Disabilities Act that we're discussing this morning. And those laws in New Hampshire and Massachusetts apply to employers with 6 or more employees. So when we're talking about reasonably accommodating disabilities, even for small employers, 6 or more employees, you should be thinking about the principles we're talking about now under the Americans with Disabilities Act, even if the ADA doesn't apply to you, but a parallel state law does. The ADA, in essence, prohibits discrimination against people with disabilities or a record of a disability or who are perceived as disabled. Importantly, it says we can't discriminate against people with disabilities or retaliate against them for taking reasonable accommodations or for exercising their rights. And relevant to this presentation, the Americans with Disabilities Act requires that we provide reasonable accommodations to qualified individuals with disabilities. Leave can be a form of reasonable accommodation. I'm going to go over this slide quickly and what I'm thinking about time, but under the ADA, for someone to qualify for reasonable accommodation, they have to be a person with a disability. I've outlined in this slide that's going to be emailed to you what a disability means. Being substantially limited in performing one or more major life activities. The important takeaway is once upon a time when the Americans with Disabilities Act was enacted back in 1990, it was hard for someone to show that they were disabled and hard for someone to show they qualified for reasonable accommodation. That's all different now. There have been amendments to the law. There's been case law that shows us that the threshold has been lower, and it's really much, much easier now for someone to establish that they're an individual with a disability. So you don't want to spend tons of time really trying to, figure out, is someone a person with disability? Yes, you should get medical information. Yes, you should do that, but understand that the threshold is pretty low and that the focus can really be, and sometimes properly should be, more on how you can help. So under the framework, you're first looking at, is the person a person with a disability? Again, that's pretty easy for folks to establish. And then the employee has to be qualified for the job. They have to have the education, qualifications, whatever necessary for the job. And they have to be able to perform the essential functions of the job with or without reasonable accommodation. What are the essential functions? I've listed things here on the slide. We're looking primarily at the employer's job description. So you want to make sure that your job descriptions are up to date and they're accurate. The employer's judgment also matters, the amount of time spent on the function, the consequences of not performing it, etc. So if you have a qualified individual with a disability, they are entitled to reasonable accommodation unless the accommodation would pose an undue hardship. Or again, if the person's not qualified, and a note that a person is not qualified if they would pose a significant risk of substantial harm to the health or safety of themselves or others. So there are some times when we're not providing reasonable accommodation, undue hardship, substantial risk of harm. And sometimes some accommodations are just not reasonable. So I don't automatically assume that everything's requested is reasonable. There's an old now guidance from the EEOC, quite old. I think this one dates back maybe to 2002, but it's still relevant, that it gives examples of times an employee might use leave as a reasonable accommodation. I've got them here. Leave could be for obtaining treatment, obtaining surgery, recuperating from an illness, obtaining repairs on assistive devices like a wheelchair or prosthetic device. Avoiding temporary adverse conditions in the environment. For example, someone with a health condition who can't work in the extreme heat, training a service animal, or receiving training in the use of Braille or sign language. The list goes on and on. There are many, many reasons why a leave of absence could be helpful to an individual with a disability. When we're thinking about leave of absence under the ADA, importantly, there is no set duration of leave. Unlike the FMLA, for example, where we know it's 12 weeks of leave, under the ADA, the duration of leave is reasonable. What's reasonable is going to depend on your workplace, the employee's job, how many other people do the job, the importance of the job. It's going to depend on many, many factors. Note that providing a leave of absence for a specific period of time, a specific reasonable period of time, often is not going to cause undue hardship. You know, say someone needs a leave of absence for 4, 8, 12 weeks, something like that. Many businesses can roll with that. And I say that somewhat glibly. I'm not saying that we just say, oh, okie doke, here you go. We're going to engage in the interactive process. We're going to be thoughtful about it. I'm just setting kind of an expectation that if there's a reasonable defined period of time, probably you're going to have to grant that for a qualified individual with a disability. In contrast, if the person needs leave for an indefinite period, they don't know whether or when they're going to be able to come back to work. Or they go out of work with a note that says they need a certain number of weeks off. But then we get towards the end of that and we get a new note that they need a certain more number of weeks off. And then we get yet another note pushing it out further, etc. Many of you have seen this circumstance, if not all of you. It's so commonplace that there can come a time when a leave of absence that was originally for a defined period of time and originally might have been reasonable can morph into a leave of absence that's really indefinite, because we really don't have confidence about whether or when that person's going to be able to return to work. And at that point, you might be able to say, you know, this is not reasonable. We cannot hold the position indefinitely. Again, you want to approach that thoughtfully, not a knee-jerk reaction. You want to consult with your counsel. You want to have a well-documented process before you ultimately reach the conclusion that you're not going to provide this anymore, and instead you're going to separate the employee. Okay. Note that employers often don't have specific leave of absence policies for reasonable accommodation. It's rare for me to see in a handbook a policy that says reasonable accommodation leave. That's totally fine, but have something, because it's useful to have the rules of the road for someone who's out on leave. It could be that ADA reasonable accommodation leave runs consecutively with FMLA if your workplace is covered by both laws and the employee is eligible for both. That's easy. But it could be that FMLA is not applicable to you or the employee or whatnot. And in that case, you want to have a policy that talks about, you know, what are the rules of this leave? What does the person have to provide? How often should they contact you with updates? At the end of this presentation, we're going to talk about personal leave of absence, which is a great form of leave, a discretionary form of leave that you can utilize in these circumstances. I just wanted to flag for you, because when you're thinking leave is a reasonable accommodation, you also want to have a policy that fits with that. I wanted to make mention of workers' compensation, focusing for a minute on New Hampshire workers' comp, although the same is true in Massachusetts. Our leave statutes on I misspoke. Our workers' compensation laws in New Hampshire and Massachusetts do not provide for a leave of absence. They provide for indemnity benefits, medical benefits. They provide a whole scheme to help an injured worker. And they can provide in New Hampshire a right of reinstatement, or in Massachusetts a preference for rehire, but they don't actually talk about a leave of absence. Workers' comp, then, if you remember back to one of our earlier slides, is an income source. It's not a form of leave. So when someone is out of work receiving workers' compensation benefits, you want to be sure that you've also implemented FMLA, if that applies to you, your workplace and the employee, or that you've implemented some other form of leave, a personal leave or something, so that you've got the two things working in tandem. I wanted to mention New Hampshire's maternity leave law. This applies to employers with 6 or more employees. Many people are surprised to learn about this law, because it's a little buried, to be honest, in one of our anti-discrimination statutes. So it's not something that jumps out at you, but it exists. And if you have 6 or more employees, what this New Hampshire law says is that you have to provide all female employees, regardless of how long they've worked for you, whether they're full-time, part-time, whatever, any female employee who works for you gets to take leave unpaid for the period of physical disability related to pregnancy, childbirth, and related conditions. Notice that unlike the Massachusetts parental leave law, which is in Massachusetts is gender neutral and applies regardless of gender, New Hampshire, females only. Massachusetts provides for 8 weeks of parental leave per kid. So you have one child, you get 8 weeks, you give birth to twins, you get 16 weeks. In New Hampshire, it's the period of temporary physical disability associated with pregnancy, childbirth, or related conditions. So if you have someone who has a healthy, typical pregnancy, if there is such a thing, and they don't need leave before they give birth, then they give birth, they might only get, say, 6 or 8 weeks of New Hampshire maternity leave because it's the period of time for recovering from the birth. In contrast, if you have an employee with a complicated pregnancy, they might need to go out of work very early on bed rest. And then the New Hampshire maternity leave law would kick in and protect their job and give them that time, protected time away from work. And that could go on for many weeks. For example, your typical pregnancy is 40 weeks long. You could potentially have an employee go out at like week 20, halfway through a pregnancy, suppose, and be on bed rest for 20 weeks, and then give birth to a child and need 6 or 8 more weeks for physical recovery. So you could have someone out for 26, 28 weeks, if medically necessary. So we don't have a specific duration of maternity leave in New Hampshire, but it's dependent upon medical certification, what the person medically needs. It is not for bonding, nor is it for adoption, which again, in contrast to the Massachusetts parental leave law, does apply to adoption. In New Hampshire, it's really a physical disability type policy. Under the New Hampshire maternity leave law, we are required to reinstate employees from maternity leave to her same or a comparable position, unless business necessity makes that impossible or unreasonable. And you should understand that that is a high standard. It's hard to show that business necessity makes it impossible or unreasonable to bring someone back to work. I wanted to mention our New Hampshire paid family leave benefit. Not many employers are involved, so I'm not going to do a deep dive on this, but I do think there should be awareness. One of the things to be aware of, by the way, is that there's a bill pending in our state legislature right now to abolish the program, to get rid of the program. So stay tuned on that. But right now, since January 2023, employers have had the option to voluntarily choose to participate in this voluntary program. It is mandatory for the state of New Hampshire to provide its state employees with this benefit, but for other employers, it's purely optional. You can decide to buy one of these plans or not. If you decide not to buy one of these plans, right now there's a very small percentage of employers who have participated. I've spoken with some who have, and they've had positive experience with it, but it's a small percentage of people. If the employer does not offer New Hampshire PFML or an equivalent benefit, then the employees themselves can purchase an individual policy through the New Hampshire PFML program. Whether the benefits purchased by the employer or the employee, the point of New Hampshire paid family leave is to provide about 60% wage replacement up to a cap for 6 weeks of time away from work. The employer can purchase a plan that pumps that up to 12 weeks. But if it's an individual plan purchased by the employee, it's 6 weeks for that wage replacement time out of work. Employers who choose to participate can choose whether to cover the premiums fully themselves or to pass some of the premium cost on to their employees. New Hampshire PFML, when it applies, can be used for the birth, adoption, or foster placement of a child within the last 12 months. The serious health condition of a family member, the employee's own serious health condition, or a qualifying exigency for the foreign deployment in armed services or to care for a service member with a serious condition or illness. Note that if an employer who's participating has 50 or more employees, they are required to reinstate the employee from New Hampshire PFML to the position they held before the leave or an equivalent position. Note also, and I don't have this on a slide, if you don't offer New Hampshire PFML and your employee buys their own policy, you cannot require them to use their own personal policy during any other form of leave. For example, if they take 12 weeks of FMLA or parental leave, let's say they give birth to a child, you cannot require that they use their own New Hampshire PFML policy concurrent with that. You can only require it if you've offered and you've paid for the PFML. If they bought it themselves, they could tack their own 6 weeks on to the end of their 12 FMLA weeks if desired. if desired, they could also have it run concurrently. So that's just a little wrinkle some people don't know about. Some differences between the New Hampshire Paid Family Leave Program, this voluntary program, and the federal FMLA is that leave to care for a family member extends beyond the family members covered by the Federal Family Medical Leave Act. Under the New Hampshire PFML, it can include the grandparents, domestic partners, and spouses of the of the employee that is covered under FMLA, but spouses of the employee's child too. So the family definition is a little bit broader. Under the FMLA, intermittent leave cannot be taken for bonding leave after the birth or placement of a child, unless the employer agrees. In other words, the employee can't force you under federal FMLA to have intermittent leave, but it can be taken intermittently under the New Hampshire plan. Contrast that with the Massachusetts PFML, by the way. Under the Massachusetts PFML, the employer has to agree or not agree. The employer can choose to agree or not agree to allow bonding leave for a new child to be on an intermittent or reduced schedule basis. The employee doesn't call the shots on that. The employer gets to choose. But under New Hampshire, the employee can call the shots. FMLA does not have a 7-day elimination period. The New Hampshire PFML does. The New Hampshire PFML also covers a broader array of employees than the federal FMLA. So those are some differences there. That was a really quick and dirty overview of the New Hampshire PFML. Many other states have paid family leave benefits. It's become one of my colleagues uses the phrase, a patchwork quilt out there of PFML. It's honestly, it's hard to understand. And so you want to know, particularly if you've got people working in other states, you want to know, does that state have a paid family leave benefit law? What does it require of you? Are you to be doing payroll deductions, et cetera? How do you count to the number of employees to see if you're covered? And then how do you administer that? If you are a multi-state employer and you're trying to approximate the same types of benefits for everybody, there's a way to write your policies to attempt to do that by providing, say, for example, paid parental leave benefit, but in those states where there's a PFML through the state that the person could tap into, that they're in the first instance supposed to tap into that. But if someone's in a state that doesn't offer that, or if the benefits are lower, the employer is going to gross up. It gets complicated, but there's ways to try to do it if you want to have a situation where you're fairly even in your distribution of benefits, regardless of the state in which one works. So I just put that out there as well, but it takes a lot of thought in how your policies are put together. I also wanted to mention military leave. The Uniformed Services Employment and Reemployment Rights Act is one of our most protective, one of our most powerful laws in the US. People who have served our country voluntarily or involuntarily, I get that question a lot. What if the person volunteered for this? Well, if someone volunteered to serve our country, let's protect them. They're working to protect us. So this law applies. Employers are required under USERRA, and USERRA, by the way, applies to employers of all sizes. Whether you're a big employer or a small employer, you're covered by USERRA. And you are required to provide military leave for up to 5 years. And in some rare circumstances, it can be even longer. So military leave can be long, and it can go on repeat. You might have someone who is a pilot in the military and they're flying missions a few times a month, and they might do that for their entire career with you. So be it. It's covered by USERRA, whether they volunteer for it or not, or required. Military leave need not be paid unless the employer provides pay for comparable forms of leave. A lot of people don't know this, but pay attention, because if you provide pay for jury duty, let's say, then you should provide pay for a comparable duration of military leave. What I mean by that is, let's suppose you provide, 2 weeks jury duty pay. Then your military leave policy should probably also provide that 2 weeks of military leave will be paid, but not more than that. I am not, to be clear, I am not suggesting that if you pay jury duty, you'll pay 5 years of military leave. I am suggesting that your policies be clear. Don't just have a policy that says, oh, we'll pay for jury duty without having a time limit on it, because that could back you into something limitless someplace else. You know, some states, of course, require jury duty pay. Massachusetts, for example, requires it, I believe, for 3 days. New Hampshire doesn't require it, but many employers will provide it. The point is to have clarity about what you provide, whether you're providing it through a mandated requirement or voluntarily. And then when you're thinking about your military leave policy, think about what pay, if any, are you providing for jury duty, which I mentioned just because it can be considered a comparable form of leave. Consider other comparable forms of leave as well, so that you're appropriately stating in your military leave policy whether it's paid or unpaid, and if paid at all, for how long, and if paid, is it an offset between the employees' regular earnings and their military earnings, or how are you going to adjudicate that? When someone is returning from military leave, they have to be reinstated to the position they would have attained absent the military leave. There's this thing called the escalator provision. If you have someone who's out on military leave for quite a while, you want like more than a 2-week training or more than a short deployment, you want to be sure you're familiar with this escalator provision. I don't have time to go into it this morning, but it's something that really bears your attention to make sure that when you're reinstating someone, you're reinstating them to the correct position and you're supporting them appropriately. USERRA also tells us that employers must reasonably accommodate the needs of disabled veterans, and employees may not be retaliated against for taking military leave or discriminated against in hiring or employment because they're serving in the military or because they're veterans. In other words, you cannot say, boy, I don't want to hire anyone in the military because I don't want to deal with that military leave. That would be illegal. So don't do that. I wanted to also mention in our few remaining minutes, New Hampshire's Crime Victim Leave Act. I'm not going to do a super deep dive on this because I don't see it used with frequency, but when it is used, it's important. It applies to employers with 25 or more employees. Massachusetts has a similar law, as do many other states. And it provides time away from work, legally protected time away from work, for an employee who's been a victim of a crime or in other circumstances that I have on the slide here, to engage with the legal process. This law does not provide time for healing or medical care or psychological care, which is form of medical care, but it's more the logistics around engaging with the court system. Some of the other laws go a little bit more broadly, providing time, for example, in other states to rehouse yourself if you need to and that type of thing. But be familiar with this if you have any employees who have been victims of crime. When I've seen it used, it's most commonly used when someone's experienced domestic violence. So note also that New Hampshire law prohibits discrimination against employees who are victims of domestic violence, sexual assault, harassment, or stalking. And then I want to finish this morning with personal leaves of absence. Personal leaves of absence are not something that's governed by a law. They're not required, but this is the place where you can get creative around offering leaves to people that you want to. And to take a step back for a minute, we've been talking this morning in a rapid fashion about some of the various federal and state laws that require us to give leaves of absence in many circumstances. There might also be plenty of leave types that you offer on a short-term basis voluntarily, PTO, sick time, earned sick time, time off for bereavement, etc. Yet, I bet you will find, if you haven't already, that there are circumstances that fall between the cracks. Let's pretend, for example, that you have an employee whose partner, they're not married to them, they're not a spouse, but their partner is seriously ill and they need time to care for them. That is not going to be covered by the federal FMLA because the person is not a spouse. Yet, you might want to support that employee in taking leave and providing the care to their person and coming back. And so you need to know, what is my policy that governs this, that provides the rules of the road for this type of leave? Personal leave also kicks in if someone's not eligible for FMLA. For example, someone hasn't worked for you for 12 months or your workplace is not so large as to be covered by the FMLA and someone needs time away from work. Personal leave could also kick in for a reason. You know, I've had employers over the years where their employees want to take time off because they have a chance to take the trip of a lifetime and they're going to be gone for 3 months. And could they please go and come back? Or they want to hike the Appalachian Trail or some other thing. So it can also be for a happy occasion. But I encourage you to think about all the many circumstances in which you might have someone who needs time away from work and you're not looking to fire them, and yet none of your existing policies fit them. This is when you want to have a discretionary leave policy. I usually call it personal leave, but you can call it anything. Compassionate leave, discretionary leave, anything you want. The idea is to have a policy that covers these other circumstances. Because it's not legally required, you have broad discretion in drafting these personal leave policies. When you're drafting your policy, consider the eligibility requirements, if any, for a leave. A lot of people like to say a person's got to work for you for at least a year, but consider the fact that you might have circumstances that arise before that mark. So think carefully about that, but you want to think about eligibility, the procedures for someone to use to request a leave. Maybe a statement in there that requests are reviewed on a case-by-case basis and can be granted or denied within the employer's discretion. There may be circumstances where you need to grant, maybe if someone is eligible for leave as a reasonable accommodation, for example, but you want to retain that discretion for other circumstances where there's not a legal mandate. You want to talk about the documentation that may be required to support a request for leave or to continue a leave, maybe include a typical maximum duration of leave. I say typical because you might have circumstances where you're required to make an exception or desire to make an exception, but it's helpful to have something typical so there's some expectation there. And then you also want to think about whether you want to permit personal leave to be taken intermittently on a reduced schedule basis, or if you want it to be taken all at once. Address that in the policy that you have discretion to design. Talk about the type and frequency of communication you expect from the person. You want to talk about benefits continuation and the payment of any applicable premiums. Remember, way back at the beginning of this, I talked about understanding health insurance continuation and talking with your broker about the things. It's going to be important to have that foundational understanding for designing your personal leave policy. A statement in your personal leave policy as to how reinstatement will be handled. And then whether you might require a fitness for duty certificate for returning from personal leave. And with that, if there are any questions, I am happy to try to take some. I realize we're pretty close to time. I'm going to advance to the slide right now that gives you your SHRM credits. And you will also receive, for all of you participating, you will also receive an email that has this information for you, as well as the slide deck. But I wanted to show you this if you're here for the credits. And I want to thank you for spending time with me this morning. I hope that the tips I provided for skillfully managing leave and some of the quick overviews of the various laws were informative for you. And I hope you have a great day.
Jen, thank you so much. We do have quite a few questions, but in the interest of time, you know, everybody here today, you have Jen's contact information, and I will happily share those questions with her as well. So thank you, Jen. Appreciate your time.
Thank you.